of introducing my paper, I am asking, are the challenges facing arbitrators in Africa different from those faced by arbitrators elsewhere? And I'm saying that some of the problems facing arbitrators in Africa are Afrocentric, while others are universal. But even the universal ones are compounded when they occur in Africa. One of the challenges is the politicization of disputes. Everything in Kenya is political. I was alarmed yesterday when I looked at the fruit salad and I did not see any oranges or bananas, but there were watermelons. So I'm wondering what the Norfolk is trying to tell us. Even the word dialogue has in Kenya gained a political meaning. I've always been suspicious of that word, I must say. Like when my wife taps me at midnight and says, "We need to talk." Disputes in Africa are highly politicized. And the reason is simple. Disputes revolve around infrastructural projects, leasing or sale of large chunks of land, natural resources, expenditure of public funds, and other issues on which the livelihoods of millions of people depend. Let's not even talk about oil and gas. The amounts of money involved in oil and gas lead to politicization of anything related to oil and gas. Land is a highly emotive subject in Africa, particularly in Kenya, Ghana, South Africa, Zimbabwe, and now I know Mauritius also. A Kenyan friend of mine told me, "You can take my wife any day, but the day you touch my land, you are a dead man." I'm alive and kicking, so you can see I've never touched his land. As for his wife, she wouldn't give me a second look. Another problem we face in Africa is lack of professional interaction. Those are the contents of my paper. You will get it in soft form in due course. So we are now on C, lack of professional interaction. It's really shameful that there is such little interaction among arbitrators and other professionals in Africa. Kenyan legal firms have linked up with legal firms in Europe, but they have not tapped into the resources available, particularly in West Africa. Nigeria has had a long interaction with gas and oil, probably 50 years. So Nigerian lawyers have expertise in handling gas and oil. But here in East Africa, we are groping in the dark, seeking help from legal practices in Europe. But our brothers in Nigeria and sisters have the skills we need. Familiarity breeds attempt. When professionals interact in practices, in meetings like this, then the next time you need an arbitrator, you will think of a Kenyan name, a Botswana name, a Nigerian name, a Cameroon name. But if these are people you have never met, you cannot attempt. Now, African governments engage foreign legal firms when it comes to representation in international arbitrations. Any wonder then that African arbitrators are not considered for appointment? You just need to visit the ICSID website. It lists all the previous disputes and the current disputes under ICSID. And you will see there the names of legal practices. I think only the Gambia has appointed consistently a local or Gambian legal practice in international arbitration. Then there is lack of diversity. The threatened species here are women, younger arbitrators, and non-lawyers. All non-lawyers in this room, please raise your hands. I'm one of them. All non-lawyers. Wow. Well done. Keep it up. Now you can see why I say they are a threatened species. A Kenyan lawyer recently challenged a non-lawyer who was representing a party in arbitration for unlawful practice of law. In spite of the very clear legal provisions in our Act allowing non-lawyer representation in arbitration. The over-enthusiastic lawyer even reported the non-lawyer to the Law Society of Kenya. Fortunately, the arbitrator himself, a lawyer, ruled in favor of the non-lawyer representative and awarded costs to yours truly. Another challenge we have is the proliferation of regional arbitration centers. I've given that a subheading, the quail eggs, which perhaps only Kenyans will understand. Last year, somebody discovered that quail eggs had medicinal value. Quails are wild birds. And demand for quail eggs skyrocketed. Many Kenyans became quail egg farmers. As a result, supply soon exceeded demand and the prices plummeted. How many regional or international arbitration centers can Africa support at the moment? I don't know. But there is an issue of national pride. And I should tell you, you can't be a real country unless you have a beer and an airline. It helps if you have some kind of a football team or some nuclear weapons, but at the very least, you need a beer. That's not my quotation. It's fully cited in the paper you will get. So in Kenya, we have, or in Africa, we have the Cairo Center, Lagos, Maritime Arbitration of Nigeria, Accra. Africa ADR is a South African organization. We have MIAC, we have got Lagos, we have got KIAC, we have OHADA, and CADR. What I believe is that the law of natural selection will ultimately apply. If you have forgotten Darwin, he's taught that the law of natural selection involves survival for the fittest and the dying out of the less suitable ones. I'm now in F, language and territorial barriers. The Tower of Babel. I won't say much about this, except that English and French will continue being the default languages of arbitration in Africa for many, many years to come. I have interrogated Swahili. It doesn't fit the bill. I'll tell you why. Okay, Swahili is widely spoken, being the national language of Tanzania and an official language in Kenya. With respect, it is generally a street-level language in Kenya, Uganda, and Rwanda. It is the default language for use in East Africa when English or French will not do for political reasons. As for whether Swahili is an African language, I stand to be corrected, but it fails for the same reason English and French fail. French and English are considered the colonizers' language. Swahili is the slave traders' language. That is why I say it doesn't fit the bill. G is to do with the African cultural context. I'll not dwell on that. Allow me to go to the elephant in the room. Germany versus Argentina. Siemens was, or is, a German company, and I have the quotation there. I have cited the source in the full document. It was found to have engaged in corrupt practices in Argentina. And at the footnote of the article I have cited, I'll read that one because it's not there. It should be noted that similar allegations were made regarding Siemens operations in other countries. In December 2008, Siemens paid $800 million as a settlement with the US Department of Justice and US Securities, etc., in relation to similar payouts to authorities in Munich. You can read that for yourselves. The French government in 1980s took out a case of national court. It took a case out of a national court in France and took it to arbitration. I don't know if there always was an arbitration clause in the agreement, in which case there would be no mischief in taking the matter out of court into arbitration. But the beneficiary of the private proceedings, or rather the beneficiary of the privacy of the proceedings and of the award, was a buddy of the French president. That is self-explanatory. Kenyans will be familiar with it. The arbitrators in ICSID could not believe their ears, because Kenya filed a defense and said the underlying contract is unlawful because somebody gave us a bribe. And based on its conclusion that bribery was against transnational public policy, the tribunal found that the contract was void and dismissed the claimant's claim. National Cereals and Produce Board versus IRAD. Here, I should mention that there have actually been 6 court cases regarding the enforcement of that award, because the arbitrator found in favor of IRAD. And even now, as we speak, there is a pending case in the Court of Appeal, so I cannot afford to say much. I do not want to face an angry judge. Now, IRAD was awarded a tender to supply white maize to National Cereals Board in 2004. It did not supply the maize, because the board refused to issue a letter of credit. The arbitrator awarded loss of profits following a finding that the board had breached contract by not giving a letter of credit. Now, loss of profits is a very contentious legal point, and I do not want to dwell very much on that. I'm sure you are familiar with the issues around loss of profits. It is on court record that the directors of IRAD had visited the arbitrator in his office with an indecent proposal. The arbitrator had disclosed that contact, issued directions expressing his displeasure with the contact, and warned, there's a spelling mistake there, and warned IRAD's advocate to make sure that such contact was not repeated. Now, when the board lost and it was seeking a way to avoid enforcement, it said the arbitrator had behaved unethically and suggested that the arbitrator should have resigned from the arbitration the minute he admitted that he had been approached inappropriately by IRAD. So the questions here are, was it reasonable for the board to expect the arbitrator to resign? Is being offered a bribe and rejecting it on record an offense? And why did the board raise the issue only after it lost? Now, the court, Justice Jage, found that the arbitrator had not behaved improperly. Actually, the arbitrator had played exactly by the rules. When an arbitrator is approached by a third party, or by a party in the proceedings, he is supposed to disclose that contact to the other side. Even if they meet in a bar, or they meet in a conference like this one, that is subject for disclosure. So a parliamentary commission interrogated the issue of that arbitration award. The reason why it went to Parliament is because of the hype created, you've seen in number 9. Kenyans were asking, how can an arbitrator order the government to pay $4.7 million to a supplier who has not delivered a single grain of maize? Sounds like a nice headline. Indeed, it made news for many days or months in Kenya. So the Parliamentary Commission condemned the arbitrator unheard and recommended a law society inquiry into his conduct. My question is LSK likely to make a finding different from that reached by a High Court judge? Before I go to the next PowerPoint, I want to talk briefly about experience, because we are told the reason why we cannot get international arbitrations is because we lack experience. I will start by saying experience in arbitration refers to experience as an arbitrator, not experience as a judge, not an experience as an advocate in arbitration, not experience in your primary profession. It has to be experience as an arbitrator. Being a football player and being a referee are two different professions. Experience in one field does not count at all in the other. Now, Professor Albert Vandenberg has listed the characteristics of a qualified investment arbitrator. You should take heed to that list because Vandenberg is a guru of international and of investment arbitration. My question is, are the international arbitration institutions suggesting that Africa lacks people who fit that bill? I would like now to go to J, experience and the law of diminishing returns. And that is why I have drawn this graph. The law of diminishing returns states that in all productive processes, adding more of one factor of production while holding all the others constant will at some point yield lower per unit returns. Now, in terms of experience or learning arbitration, my contention is that the learning curve, as it is called in other circles, is very steep initially. Once you complete your training or once you get your first arbitration, you start learning very difficult things there. That curve is very steep the first probably 2 or 3, maybe 5 appointments. Within the 5 appointments, you will deal with jurisdiction, you will deal with non-cooperative parties, you will deal with gender, you will deal with so many issues, such that at some point, there isn't too much new learning to do. Now, it's the same in other fields, like in learning how to drive a motor vehicle. After you have driven a motor vehicle for 2, 3, maybe 5 years, you cannot really become a much better driver by the time by driving for 30 years. If you are recruiting a driver, you'll probably look for somebody who has 5 years experience. After that, the additional experience is only age. It's age, not experience. Don't mistake age for experience. And what I'm saying, therefore, is the reason why we have been denied international appointments is not the experience. We have the experience. By the time you have handled even 5 arbitrations, even 5 domestic arbitrations, you are qualified to handle international arbitrations with one rider. The seat of arbitration is a very difficult concept for many people, including lawyers. The minute you know what a seat of arbitration is, and you have done 5 domestic arbitrations, you can become an international arbitrator. I'll not try to explain what the seat of arbitration is. Allow me to go to the next point of professional training and mentorship of arbitrators. I'll give you a quotation. There is a failure on the part of everyone concerned, and in this I include parties, lawyers, experts, and arbitrators themselves and the courts, to recognize that arbitration is, by its very nature, a wholly different method of dispute resolution from litigation, requiring a wholly different approach from the very onset. That's an article from H.M. Sims. The article is entitled "The Way Ahead, Adopting to Change." The source is shown in the article. So arbitration is a different animal, different from Judge Judy, and different from Vioja Mahakamani. But in the absence of mentorship, arbitrators invariably turn arbitration into private litigation. So we should have in Kenya, in Rwanda, everywhere, a structured mentorship program for a specific period, say 1 year, in which The new arbitrators would attend hearings, subject, of course, to the consent of the parties. They would prepare draft or shadow awards and directions, and discuss with the mentor any matters of concern or of interest. Now, training in professional arbitration is very expensive. Rwanda offers subsidies to its nationals in order for them to attend the arbitration courses. No financial assistance is available in Kenya or in any of the other African countries. There is also now is there open bias against African arbitrators? I will pose the question and not answer it. "30 more minutes. In closing, I would like to say that disputes arise from business dealings. If Kenya is not trading with Sierra Leone, there will be no disputes between Kenya and Sierra Leone. If Tanzania is not trading with Morocco, there will be no disputes, and there will be no work for us. So we should encourage them to do some more trade, then we can have some work. There is also need, I think, for specialist arbitrators who do nothing else. I am a property valuer, I'm an estate agent, I am 101 things. I'm aware of only one Kenyan arbitrator who was specializing in arbitration and doing nothing else. He had closed his legal practice and gone full-time into arbitration. And you needed to see him at work. I was honored to appear before him. He was a great arbitrator until he was poached by the government and taken to the bench. Another thing is that African arbitrators must get out of their cocoons in order to be seen and heard in the international arbitration arena. It's not just about appointments. We need to attend those conferences in London, in New York, in Sydney, everywhere. We need to prepare academic papers for publication. We basically need to be seen and heard. If we just sit here telling ourselves how important we are, we will just listen to ourselves. A few suggested solutions. I've talked about structured mentorship. We need a continental arbitration body to address African issues. Just as an example, from May to August, 3 months, we have had 4 international conferences on arbitration in East Africa. We had one in Kigali, then we had LCIA in Kampala. We have this one, Chartered Institute of Arbitrators. We will hold it in August. So within 4 months, 3 or 4 months, we have 4 international arbitration conferences. We need some coordination there. And that can only come through if we have a global voice. African governments must appoint competent arbitrators in ICSID. Some African governments have not bothered to fill their slots. Each African government which is a signatory of ICSID has 8 slots. And I'll give you an example in closing. Of the 8 slots, Uganda has filled 7. One of the 7 is Mr. Godfrey Binaisa, QC, barrister. Some of you here, even the Kenyans, have no idea who Binaisa was. past president of Uganda. He passed away some years ago. He is still on the exit list as a nominee of the Ugandan government. It would be very difficult for him to take an appointment. Of the seven others, their tenure, and it's listed there on the exit website, the seven others, the tenure of office expired in 1970s. Some of them in 1973, one in 1979. Now, Tanzania, of the 8 slots, it has filled 4. And of those 4, the tenure ended in 2005. Now, Kenya is different. I'm happy to say. We have filled all our slots with living people. And their tenure of office will end, or will run up to 2018. You might want to know who the names are. One is Jerry Kariuki. She's a lawyer and chartered arbitrator. The other one is Professor Gedhu Muigai. You saw him yesterday. The third, Philip Murgo. He is an advocate. Fifth, Amos Wako. He is a fellow of the Chartered Institute of Arbitrators and our former AG. Then Jackie Kamau, chartered arbitrator and judge. The next one is Farouk Khan, a civil engineer and I believe a chartered arbitrator. Seventh, Dr. Ken Kiplagat. He is an advocate. The last one is Norman Mururu, chartered arbitrator, quantity surveyor, and advocate. We call him in Kenya the arbitration guru. So I would like to close with that note that much as we are saying Europe needs to listen to us, we also must do some things. And I have given examples of the things that we need to do in order to meet Europe, or in order to negotiate effectively with Europe. Thank you.